Holocaust denial, which Rick talked about, poses a very, very interesting example. And a number of universities have had to contend with the question, can we fire a professor who has participated in Holocaust denial activity? And you see this poses a kind of tension between the ideal of the university as a marketplace, the theory being universities don't censor professors based on their intellectual viewpoints, and the idea of a university as not simply a moral space, but a space that adheres to certain norms of academic integrity, historical proof, rationality and argument, etc. Sometimes this question has been so nuanced that it has mattered to the university whether the, is that humming for you all? It's not?
Can't hear it.
Good. Sometimes it's been so nuanced that it's mattered to the university whether the professor was in the history department or the engineering department. The theory being you could fire a history professor for engaging in Holocaust denial because it's such bad history, it's so counter to ordinary norms of academic integrity in the documentation of historical positions that it would be like firing a physicist for adhering seriously to the notion that the earth is flat. On the other hand, if the professor is in some discipline in which his or her responsibilities have nothing to do with history, one can argue that the professor, if he or she turns up to have their name on one of the web pages that Rick has described, is now not participating in the academic realm in the same way that the history professor might be, and it would be permissible. I don't have that one figured out yet, but I want to give you a sense of some of the tensions that one might have to confront in that arena. We take the last 10 minutes or so to talk about that final area, the ability in our society in the United States to take criminal or civil action against hate speech. And to try to make this simple, I'm going to divide First Amendment doctrine and First Amendment theory, free speech doctrine and free speech theory, into two perspectives. The first perspective is what I will call the European view and the early American view. And the second perspective is what I will call the modern American view. The European view, the view that we inherited from Great Britain, and the view that continues to exist in most of the world, and certainly it exists in places like France and Germany and the United Kingdom, was the original American position with regard to free speech. And its principal architect was Oliver Wendell Holmes. And in the early Holmes thinking on free speech, which was the early American thinking, Holmes posited that if speech had a bad tendency, if one knew that the speech had some tendency to cause harm, disruption of the draft, for example, interference with national security interests, and if the speaker intended to cause the harm, so if the tendency and the intent aligned, then there was nothing in the First Amendment that prevented the government from penalizing the speaker. That was the early Holmes view, and it is the dominant view throughout the world today. It lasted in the United States well into the last century. And there are two cases that exemplify this bad tendency conception. One from 1934 and one from 1952. I'll describe them both to you briefly. The 1934 case is a hate speech case called Chaplinsky versus New Hampshire. Chaplinsky was a Jehovah's Witness railing against people of other religious views. And he was engaged in a rant in a public park. It made the crowd uneasy. A police officer tried to calm him down and get him to chill, but he wouldn't. And so the police officer put Mr. Chaplinsky under arrest to remove him from the unruly situation. And as he placed him under arrest, Mr. Chaplinsky called the officer a goddamn fascist. And then he said the whole city of Rochester, the mayor and everyone else, were a bunch of blankety-blank fascists. For all of this activity, which was hateful, for all of this activity, Mr. Chaplinsky was sent to jail. And the Supreme Court of the United States affirmed the conviction in a beautifully written opinion. And at the heart of that opinion was the notion that there are certain categories of speech that have never been protected, including fighting words, the profane, the libelous, the obscene, etc. And then in one sentence, the Supreme Court perfectly captured the early American and European view in one sentence. The court said in that one sentence, this type of speech contributes nothing of any serious worth to the marketplace of ideas. Whatever slight social value it might have is outweighed by the damage that it does to morality and good order. And so the court basically said what we would all think of as true of hate speech. It contributes nothing that we can imagine of any serious nature to the world of ideas, but we know it is corrosive of our sense of morality and our sense of order. And so the court said it's not protected by the First Amendment. An elegant restatement of the bad tendency test. In 1952, in another great hate speech case, the Supreme Court took the Chaplinsky view in what was the high water mark in the American experience for the European view. It was a case called Beauharnais versus Illinois. Came from my hometown of Chicago. It involved a racist group in Illinois called the White Circle League. The White Circle League, a kind of Illinois version of the Ku Klux Klan, or would later be the Skokie Nazis, distributed leaflets in the south side of Chicago that were racist and had racist caricatures of African Americans in Illinois. They didn't use the phrase African American, as you might guess. For that, Beauharnais, the racist leader of the White Circle League, was criminally convicted under an Illinois hate speech law, an Illinois group libel law. It was a criminal form of group libel. Beauharnais in the Illinois Supreme Court said, all I was doing is passing out leaflets, and none of it led to violence. And I want an instruction that says you can't throw me in jail unless my speech created a clear and present danger of violence. The Illinois Supreme Court refused to give him that instruction. The case went to the Supreme Court of the United States, and the Supreme Court of the United States rejected Beauharnais' First Amendment claim and rejected the view that he was entitled to a clear and present danger instruction and affirmed the decision of the Illinois Supreme Court. The decision was written by Felix Frankfurter, and Felix Frankfurter openly invoked the memory of the Holocaust. And he openly invoked the idea that we know from the Holocaust where hate speech leads. And then he talked about the history of racism in Illinois, and he said the Illinois legislature could essentially reach the judgment, we don't want any Holocausts here. And in a beautifully written opinion, Justice Felix Frankfurter, the only Jewish member of the court at the time, said that the First Amendment doesn't protect this kind of speech, which we know has a bad tendency and damages so severely the social fabric.